In the last few years, a lot of people have anticipated litigation emerging as a powerful tool in the fight against climate change. It's easy to understand why. Recently, there have been significant decisions coming out of Europe and the US. But what does litigation actually achieve in terms of successful climate change adaptation? At a recent presentation at QUT's Climate Litigation Symposium, I explored this question. It's irrefutable that climate change is occurring. It's irrefutable that governments and industry will need to adapt to changing climate. It's not irrefutable that litigation is the most effective way to achieve change. I don't dispute its importance in many situations, particularly when actively seeking to create an awareness of climate change, where individuals and organisations fail to address climate change concerns. I do, however, dispute its adoption as the first or the only legal solution in dealing with the impacts of climate change. Litigation has progressively been seen as a way to promote climate change adaptation. It does this by encouraging governments to consider the costs or benefits of action or inaction in the face of climate change. But there are inherent limitations in adopting a litigious approach. Litigation is often backward-looking, seeking to resolve some past error. It doesn't necessarily look to clear long-term adaptive goals. And the powers of the court are limited too. They don't extend to policy issues. The reason why there is an action to climate change is often because of policy. And that's undoubtedly an issue. But it's an issue that can be resolved, and not through litigation. But how do we achieve this change? Well, we educate decision makers to think like lawyers. How do we do this without them having to complete a law degree? We show them how to look at climate change issues as a lawyer would, and to use legal reasoning to recognise when a legal issue might be arising. How to make an assessment as to the magnitude of that risk, and appropriately consider what further steps may need to be taken. It was a model that we developed because we saw that despite all the work that was going into climate change adaptation, very little adaptation was actually happening. Climate change litigation as a sole solution is unsustainable. Climate change will not, and legal practitioners should not, tolerate unsustainable solutions.